Hello, everybody. Laurie White from the Greater Providence Chamber of Commerce. Welcome to episode number 91 of Chamber TV. And today we have a great topic. We are talking about estate planning for your health, for your heirs, for your finances, all kinds of timely topics. And we have a power team with us who is going to walk us through all of the things that you need to know, particularly now during the pandemic. So I'd like to welcome Kristen Moonan and Amy Stratton from the Providence law firm Moonan, Stratton, and Waldman. Hello, everybody. How are you?
Thanks so much, Laurie. This is great. We really appreciate the opportunity to be here. We're new chamber members, and this is quite an opportunity for us to get to talk to people and get to know more of the chamber members out there, and to thank the chamber for everything they've done over the last few months to keep small businesses connected to each other. This has been fantastic, so thank you.
Well, we are thrilled to have you aboard and look forward to working with you over the course of the next year or so, because these are such important topics, and we have to make sure that we shine a spotlight on those topics that some of us may, in fact, want to studiously avoid, if you know what I'm saying. But, estate planning, who wants to talk about that, right? But hey, it's probably one of the most important things and one of the most important responsibilities we have as individuals, at least to our families. So I want to say hi to you as well, Kristen. How are you today?
Good. How are you, Laurie?
Doing well. So tell us a little bit about the firm and how you're doing during these crazy times. Are you going into the office? Where are you located?
So I'll start with that. So we are a small firm in Providence. We're on the east side of Providence. And we have, there's just 5 of us here in the office. We have 2 attorneys and 3 support staff. So we've been in the office every day. And with everything that's been going on in the world right now, we're thankful that we're extremely busy with our practice right now. So we do estate planning, elder law. We do some trust and estates administration, and we also have a corporate side to our practice as well.
Mm-hmm. Excellent. And Amy, how are you doing? You're obviously in the office today, and you are. What is your specialty?
Kristen and I both have the same specialties, so we do that broad base of estate planning, which is one umbrella of our practice, which is everything from simple estate planning to more sophisticated estate planning for people who are looking at retirement, or even our high net worth clients. We also do some special needs trusts and some Medicaid protection trusts for our elderly clients who are looking at a long-term care scenario. Then we have the probate arm and the administration arm of our practice. After somebody passes, we're able to help people transition and make sure that we're able to transition their assets to their beneficiaries. And then we also have the corporate side of our practice. So we're helping business owners decide how they're going to get their next generation either into their practice or if they're going to sell their practice. We get them ready for that event.
Mm-hmm. Fantastic. Okay, so what is it about the human psyche, Amy and Kristen, that causes us to not want to deal with these issues? What have you seen along the way, and what is your power tip for getting folks to understand this is something that must be dealt with?
The 2 certainties in life are death and taxes, so we need to plan for both. We work with a lot of professionals out there, whether they be financial advisors, accountants, other attorneys, and they're able to help people plan for different events in their lives. What we're able to do is we're able to take people who may not want to talk about these difficult issues, such as incapacity, such as death planning, and we're able to get them to a point where it becomes just a plan. It's something that is going to happen. We want to be sure that we're able to plan for that event and be able to facilitate the transfer of assets from you that you've worked hard to acquire over your life to the beneficiaries that you want. And that's our little view into somebody's psyche. We do try to make it as easy on people as we can, because I know these are difficult conversations to have. So I think that having a light touch when we're having that conversation, if it's really bothering people, is really important, because it doesn't need to be this morbid conversation. It really just needs to be part of an overall plan for your life.
Mhm. Well, particularly if you start planning early enough where you don't feel as though it's perhaps, an imminent event, death is not at your doorstep. So,
Right.
having the benefit of time and perspective, I think is really important. Kristen, do you concur with Amy's assessment on nothing?
I do, yes. And one thing I do tell my clients is that it's important to plan while you're healthy, and in the right frame of mind to do the planning. The worst thing is to wait until you have a sickness or a health crisis and to do the planning. Then it becomes more difficult in those circumstances to do the planning.
Mm-hmm. What ages are you advising people to get their act together, if you will?
When it comes to incapacity planning, we're finding that more and more people are coming to see us with especially college-age children, because what happens is once you're the age of majority, once you're the age of 18, your parents are no longer able to help you. So if we have college-age children, say out in California, Colorado, and we have parents who live here in Rhode Island, what we want to be sure is that their children have incapacity planning documents. God forbid somebody has an event where they're stricken with COVID out in another state. We want to be sure that their parents are able to help them. Simple documents like a financial power of attorney, a healthcare power of attorney can be critical so the parents are able to help their kids. So we're seeing as young as 18 being the start. But we're able to help people through the whole spectrum of events of their lives, whether it be they become parents for the first time. We need to be sure that we're naming guardians for their children. As people begin to acquire assets, that's usually when we start talking about revocable living trusts and wills, just to make sure that those assets are transferred properly. And then as folks get older, we start talking a little bit more about long-term care, possible events, and what kind of plans that we can put in place for them. The biggest question we see is, how do I save the house? So what we're able to do is we're able to help people address that question as their life changes.
Kristen, what are you seeing during these particular times of COVID? The fact that you folks have been extremely busy is probably an interesting sign of the times.
Yes, it is. So we're seeing a lot of clients that want to get those basic documents in place for incapacity planning. So we are doing, healthcare powers of attorney, living wills, financial powers of attorney for clients. As Amy said, even, college students need to have these documents in place. It's important. So we're seeing younger people wanting to get these documents in place. And in our practice, we're seeing more healthcare providers, first responders, teachers, who are concerned about their planning and want to make sure that they at least have a basic estate plan set up.
What are the key elements that folks need to have at the ready and to be prepared? So let's just kind of walk us through a typical scenario. So we have a live audience today. We are live on Twitter. We are live on Facebook. We are live on YouTube. So we may have, in fact, some folks that are listening to Amy Stratton and Kristen Moonan talk about estate planning and getting your life in order, if you will, as just one element of a very sound personal business plan. What is the first thing someone should consider? Take us through the steps and make it easy and accessible for our listeners.
Well, what we do is there are two major issues that people need to address on a basic level when they come to see us. First is incapacity planning, and second is death planning. Incapacity is something that nobody wants to talk about, but if you are unable to make decisions for yourself, you want to be able to have that control where you're naming the person who's going to step into your shoes and make decisions for you. These are relatively simple documents, but these are the documents that actually protect you. When we're talking about a will and a trust, that's death planning. That's protecting your family, your beneficiaries, your important charities. But incapacity documents are really important to protect you. So the two main documents we look at when we talk about incapacity planning are healthcare power of attorney and a durable financial power of attorney. The durable financial power of attorney allows someone to act as your attorney in fact They step into your shoes and are able to handle financial affairs for you. It's important that the person really know what you think. If there's an event that happens, and whether it be a stroke or a coma or all of these other events that we talk about with incapacity, we want somebody who's going to have the same mindset as you when it comes to finances. So we'll have somebody name an alternate or two, and then give them pretty broad-based powers that they can step into your shoes, whether it be paying your bills, making investments, making gifts, whatever needs to be done if you're not able to make financial decisions for yourself. The healthcare power of attorney is a little bit different, and that can actually be the more emotional document of the two. In Rhode Island, what we do is we take what's called a healthcare proxy, and we also take the living will or advanced care directives, and we kind of put them together into what's called the healthcare power of attorney. We separate those out in Massachusetts, where Kristen and I are also licensed. But in Rhode Island, we put them together. So what we do is we have somebody who's going to make healthcare decisions for you. And again, this is somebody who needs to be really attuned to what would be your decision if someone needed to make healthcare decisions for you, what you would want in that situation, because they are stepping into your shoes and making those decisions. After we go through that piece of it, that's when we start looking at the advanced care directives, or sometimes called the living will. And that's taken on a new meaning here, because what we've seen in the past is that we have people that come in, and I talk a lot about the spectrum of folks that think about living wills, and they'll start by thinking, I've got one group that as soon as I start talking about feeding tubes or ventilators, they're saying pull the plug. Before I can even get the words out of my mouth, that's where they're at. They may have been through an event with a parent or a loved one in the past, so they may have very strong feelings about this. I've got another group of people sort of on the other side of the spectrum, and I'm related to some of these people, and they will say, no matter what, you keep me alive. I don't care how much it costs. I don't care what you need to do. You need to put me in a bariatric chamber like Michael Jackson. You go ahead and do that. If you need to do something like a Ted Williams type of proposal that's out there, you do that. You do whatever needs to be done to keep me alive. It's a smaller group, but they are out there. No judgment. A lot of people fall in the middle where they say, I would really, depends on what the circumstances are. It depends on what the facts are that are going on. I really want somebody who has all of the facts available to them, maybe have my medical records available to them, and then they can make a decision for me. And I leave that up to them. It's really important that these people have a conversation with their healthcare proxy and really know what they would want in certain situations. So we have a whole list of discussion questions that people can go through so they can have that type of conversation. What we're seeing more now because of COVID is that people are less likely to be in that pull the plug category where they say, absolutely, I would not want a ventilator, because in certain circumstances you would. So we're finding that there's more people in that middle ground with incapacity planning where they're saying, I really just want to leave it up to my healthcare proxy and have that conversation with them. So that kind of sums up the incapacity planning piece. So then we get into the death planning piece where we start talking about who is going to assume your assets after you pass away, and who is going to manage this whole process of transferring your assets. So the manager, so-called, would be an executor for a will or a trustee for a trust. And really the conversation we have is what's more appropriate. Is it a will or is it a trust? A lot of that depends on the number of assets, the type of assets, the value of your assets, who your beneficiaries are, and what your tolerance is for having your family have to go through that probate process after somebody passes. Some people say they want absolutely everything buttoned up, tied in a bow, handled, and it's going to be private, and they want the least amount of impediment in order for those assets to be transferred. We'll put those people into a trust plan. Other people say it really doesn't matter. We're going to be looking at, probate doesn't really matter that much to me. And so we'll put those people in a will plan. But there's a lot of other pieces that go into that conversation. So I figured I would just throw this over to Kristen just to see if she has anything to add, because I'm talking an awful lot.
Yeah, Kristen, it sounds as though, for someone who's just, beginning to grapple with this, get us in the mindset of how to pick up the phone and, first of all, choose the correct counsel, but also how to get the ball rolling, if you will, and how long does it take to get buttoned up, as Amy was saying?
So, I tell people, don't be afraid to pick up the phone, call, and if you call our office or email our office, we can get you set up with a consultation via Zoom, which is pretty easy. We do have a worksheet that we send out to clients. So we really need to, know what your assets are and who your heirs are and who your beneficiaries are, in order to have, a productive conversation as to what planning would be appropriate for you. But I do tell people, the process is not painful, and most people tell me, after they've completed the process, that it's much easier than they thought it would be, because we really walk them through all of the steps. And when, talking about the time frame to get a plan done from start to finish, I usually tell people it can take anywhere from 4 to 6 weeks from the time we initially meet till the time that, everything's in place and in order. But we can accelerate that if needed. So we do some expedited planning for clients that need expedited planning as well.
Mm-hmm. So it's a fairly compact timetable. If someone were serious about it, they could get it done fairly quickly and check that box, and know that they had the material done and that it was stored in the same place and they had access to counsel and the like. So what about conversations with family members about these? How do you prepare your clients to have those very difficult conversations, either around, well, let's start with the healthcare power of attorney, and the desire of someone to have a certain level of treatment. How do you communicate with your family about your wishes in a way that's not terribly emotional?
That is a great question. Usually what I tell people is people will leave our office with a big book of documents, and not to focus on the documents as much as the conversation, but the book is awfully big. And I tell people, you don't want to just put this out on your coffee table, because people are going to be your family's going to be very concerned if they just see this giant estate plan sitting on your coffee table with no explanation as to what's going on. I also tell people you don't want to hide it away. You don't want to put this in a safe deposit box somewhere where no one can get at it. So the documents themselves should be somewhere that's accessible. And I think that it can be helpful to have that visual reminder where we have a binder that we can use to tell people this is where everything is. It needs to be updated, but we're going to put all of our important papers in this binder so that you don't need to think about anything. But when it comes to naming proxies, such as the healthcare proxy and the financial power of attorney, or attorney in fact, those are tough conversations to have, especially if we're dealing with younger children. I think that can be really difficult. In younger, I'm thinking even, teens, 20s, they're really not usually prepared to have these type of conversations. What they need to know is that it's a plan, and it's in place because the parents care about their kids, and they want to be sure that the conversation has been had, that they know that everything is taken care of. Nothing else needs to be thought about. Everything has been tied up, whether it be in the perfect bow with a revocable living trust, or we have something in place with a will. Everything has been taken care of. But that sometimes that person needs to be taken care of as well. So if it comes to a healthcare decision or a financial decision, they're going to have some guidance in that document. They're going to have some guidance in that folder. And that'll help them make the decisions they need to make.
Mm-hmm. Yeah, it's interesting that you bring that up, because this also presumes that that your client has already thought through these issues.
Right.
So that's it.
We do, and we find that people actually really haven't thought much about the issues. Sometimes it's a New Year's resolution. I had a few people come in since Thanksgiving who told me that they made a New Year's resolution that they were going to do a will this year. They were going to do an estate plan, and they needed to get it done before December 31st this year because they promised themselves that they would. So we're getting it done, but as we're making decisions, you realize that they know they need a plan, they know they need this in place, but they haven't made a lot of those decisions about who is going to manage this process, who is going to be my healthcare proxy, who's going to handle the will and the trust, and what do I think about these things? So we really need to meet people where they are, and I find that some people do want to move through quickly, and we get them done in that 4 to 6 week process that Kristen mentioned. But I have other folks who really agonize over these things, and particularly when it comes to charitable organizations, they may have a list of their favorite charities that they want to be able to give back to, and they don't know how to do it. They don't know whether to do that during their lifetime. They don't know whether to do that after they pass. They need to pick these organizations. They need to pick percentages or amounts that they're going to be giving. They're really important decisions for people, and it can take a while to process that. So as much as we have people who will get this done in 4 to 6 weeks, I've got several others who would take a significant amount of time to make these decisions, and we just work with them. I know Kristen's had some of these as well.
Kristen, the notion of having a difficult conversation about healthcare certainly is a very real and palpable situation, but I imagine in your role, the notion of having difficult conversations with heirs or heirs that are not going to be heirs, equally difficult to coach your clients through.
Yes, those can be difficult conversations to have. And sometimes clients don't want to have those conversations. So sometimes, the clients aren't going to share with their children who the beneficiaries are under their plan, and that's perfectly okay as well. So we see that frequently. And what I tell all of our clients is that, most of these decisions are not set in stone, so they can change their mind. So, if they may choose one person to be an agent on, their healthcare proxy, they may have sort of beneficiaries named in their plan, but that's something that we can revisit when we review the plan every few years. So, they need to make a decision, but it's not set in stone.
We have a number of questions here from our listeners and viewers that are coming through on Facebook. Again, we are live on Facebook, we are live on YouTube, and we are live on Twitter. And we are talking with Amy Stratton and Kristen Moonan. And we're talking, about a tough topic. We're talking about estate planning, but they are assuring us that the process is manageable, that it's doable, and it can be done with only a modest level of stress and pain. So let me get to a couple of questions. This one's from Catherine, and she wants to know, if a single adult child is incapacitated and has no live-in or children, does a parent have automatic authorization?
I'll take that one because that's been coming up quite a bit for us. What happens is after an incapacitated adult becomes 18 years old, it's very similar to that college student situation that we were talking about. No matter what, at 18 years old, a child is emancipated. So what we need to do is at that point, we need to get guardianship over an incapacitated child that you have. So we'll go to probate court and go ahead and get those guardianships. And what happens is we're able to represent either a petitioner, so a parent who wants to go in and make sure that they have guardianship over their child. And sometimes what we do is we're actually appointed by the court as a guardian ad litem. So we're actually representing the interests of the child. And both Kristen and I have been on both sides of this. It's a very common procedure. What happens is we need to have what's called a DMAT filed with the court. And really, it's something that's filed by the doctor. And what is happening, the medical report is actually showing what the limitations are of that incapacitated child. So if there is a way for that child to be able to have complete control, say over either their finances or over healthcare decisions, the court is going to do the minimum that needs to be controlled by somebody else, just to make sure that that child is able to have some sort of controls over their life. And if they cannot, that's okay. They'll appoint a guardian for both finances and for healthcare matters.
Mhm. So, Kristen, you two have been on both sides of this, the guardian ad litem and also the petitioner.
Yes, yes. And so we also, do some special needs planning for clients that have, children that have disabilities, so we can represent, them in getting a guardianship for their child with a disability. And we can also, do some trust planning to set up special needs trusts for that child down the road as well.
Catherine has a follow-up question. She wanted to know the acronym that you were describing in terms of the designation.
It's a D as in dog, MAT. That's the actual report that's filed by a doctor with the court.
Right. It actually stands for Decision-Making Assessment Tool. So that's the document that really gets the process started.
Yep.
And Catherine is clarifying that she's thinking COVID or a car accident, hopefully temporary, still the same process, right?
It would be. We could get a temporary guardianship appointed as opposed to a permanent guardianship. When the question was asked, I was thinking more about the permanency of disabilities, but yes, for COVID or for a car accident, something that is temporary, a temporary guardianship could be ordered by the court.
Mm-hmm. Okay, Catherine, I hope that answers your question. Let's go to Carol, and she wants to know, is it common or advised to have your attorney serve as a co-trustee of your trust?
Okay, I can take that one. So it is common, but it really is on a case-by-case basis. So it really depends on the client situation. So a lot of times, clients will have a trusted family member or even a financial institution or an advisor that they want to serve as trustee of their trust. But if it's a family member and the family member doesn't feel comfortable serving alone, then certainly an attorney sometimes can serve as a co-trustee along with the family member.
Amy, any thoughts on that?
Yeah.
When does your attorney, does that role take on a bigger job, if you will, in other areas such as this?
Well, what's important to remember is that a lot of people are thinking, well, I want my oldest child to be my trustee, or I want my best friend to be my trustee. The most important thing to consider when you're choosing a trustee is this person able to handle financial matters? Do they have experience handling financial matters? Are they organized enough to be able to keep a listing of the ins and outs going in and out of that trust account? Because they're going to need to account for this either with a court or with the beneficiaries. And it's really important to be a good record keeper and someone who really pays attention to detail. That's not necessarily your own family members. Everyone has their own strengths and weaknesses. Handling finances are not necessarily everyone's biggest strength. That's where an attorney or a financial institution or an accountant could come in and be a professional trustee, whether they serve with a family member or serve on their own. And it can usually work out for the best for people. Some people are concerned about fees, and professionals do trust fees to serve as co-trustee. But it can really be helpful for family members who are unfamiliar with this kind of accounting and record keeping that's required when you're a trustee.
Mm-hmm. Well, this is a very important decision, whom you select to do these processes for you when you are either deceased or whether you're disabled or temporary or permanent. You don't want to take these decisions, lightly, and you want to give it a maximum amount of thought and consideration. And also, I imagine, Amy and Kristen, that if circumstances change in your life and you've had a falling out with an individual, as an example, you could always go back and revisit who those individuals are.
Yes. So what I tell clients is that we should really review their plan every 2 to 3 years, and have a checkup, a sit down, and just go over what's changed and has anything changed in their family dynamics. Are the people that they've appointed in the various roles still appropriate to serve in those roles? So that's something that we recommend, clients sit down with us every few years and go over those things and review them.
Mm-hmm. So we're talking about estate planning for your health, for your finances, for your assets, for your heirs. And Kristen and Amy are thought leaders on these topics, and they are with the firm Moonan, Stratton Waldman in Providence. Excellent members of the Greater Providence Chamber of Commerce, I want to point out. And we're taking questions from our viewers and listeners that are either watching on Facebook, Twitter, or YouTube, watching this live. So Sharon wants to know, what is the cost range to set up for either or both of these scenarios?
Well, it's always a great question. And what happens is we have to have our pricing. I can give ranges, but what happens is it really depends on the complexity of the plan. So if we have people who come in for a will plan, that would include the powers of attorney that I mentioned before, both health and financial. And what we're looking at is it a single person? Is it a couple? Do we have any special needs children that we need to be doing some planning for? Are there any particular concerns about who would serve as guardian of those children? If they're under the age of 18, we want to be picking a guardian. So we also want to be looking at physical placement versus finances. So do we need to have a trust that springs out of that? Sometimes we're talking about testamentary springing trust. So what I'm doing is I'm peddling here, and I'm not really giving a real straight answer, which, attorneys, the biggest joke is the answer to any question is it depends. In a way, it does depend. But what I can tell you is that the range is anywhere for our firm, anywhere from $1,000 to $3,000 for a will plan generally. And it'll be, say, $3,500 to $6,000 for revocable living trust planning. And that will incorporate a little bit about the different scenarios that we look at and the different issues that we need to address in those documents.
Mm-hmm. Mike has a follow-up question on that point. He says, if you have an estate planning book, the binder that you are referring to, the dreaded binder that's up in the he says, but if it's outdated, how hard is it for you to update that book, taking over for another attorney?
Can I say it depends? It really does depend. It depends how old it is, because we have a lot of updates in the law that come down. And it could be a new estate tax planning threshold that we have. It could be, we just recently had a change in the Secure Act, which really changed our planning around the distribution of IRAs and how that's going to work. So the law can change, as well as some of the factual things. Factual things meaning, if we want to have a new executor or a new trustee or a new guardian named, those are easy fixes for us to do an amendment or a codicil to a will. But when it comes to actual legal changes where we need to insert new provisions having to do with either changes in the law or changes in life, that can get a little bit more pricey. It's something that we need to look at a case-by-case basis.
Mm-hmm. Kristen, what are some of the changes in Medicaid law? I know early on, a number of years ago, there was a race to get everyone to come in under a certain deadline to shelter their assets into a trust so that the heirs would be spared the drawdown of nursing home fees and the like. Where does that stand in terms of a family who doesn't want to see mom become, use all her assets on nursing home care, as an example?
Right. So under the Medicaid rules right now, there's still a 5-year look back period. And so for a lot of clients, we are doing proactive planning and still setting up Medicaid trusts. As Amy mentioned previously, a lot of people are concerned about protecting their house, and they want to be able to protect their house for their children in the event that they need long-term care. So we are, we do set up a lot of asset protection trusts to shelter the house and potentially other assets as well. from nursing home care. But the important thing for people to keep in mind is that 5-year look back period. So this is a planning that you can do. You shouldn't wait a long time to do this planning. The sooner you do it, the better.
Yeah. So that's certainly another reason to, get on it sooner rather than later with the 5-year look back period. There wasn't always a 5-year look back period. There was a more compressed timetable, as I recall.
I recall that as well, and there has been discussion over the years about stretching that look back period to 7 years and more. So it's something that we need to keep our eyes on. We're actually part of a group here in Rhode Island. It's NALA. It's the National Association of Elder Law Attorneys, and we have a Rhode Island chapter here. And we're really lucky to have it because it's a very small group of estate planners that do elder law planning. And what we're trying to do is we're trying to stay current on the laws because they change so quickly. A lot of it's by regulation. A lot of it just happens. We've had a lot of changes in terms of income and asset limits over the years. And we're very lucky to have it as a resource for us. We're able to advise our clients as the law keeps changing. We don't know what's going to happen, but right now we do still have the 5-year look back.
Mm-hmm. You know what question I hear asked a lot, and that is around when a parent is ill, as an example, and not ill enough to be in a hospital or doesn't want to be in a hospital. They haven't reached that point where they're, totally disabled. Can have some care at home, just need some basic care, whether it be, CNA type. How do those services get paid for other than private pay? Are there any examples of proposals that are in the works that would make it a bit more flexible as a covered event?
And that's something we talk about all the time in our NALA chapter meetings as well, is whether assisted living or home health care services can be paid for by the Medicaid program. Because when we're talking about long-term care, especially for skilled nursing care, we're talking that, which by that I mean a nursing home, that's about $10,000 per month on average in the state of Rhode Island. And there's only 3 ways to pay for it. One is private pay. So you're writing a check for $10,000 to the facility every month. And some people are able to do that. Another payment source is through long-term care insurance, which can be very helpful. People know that if they have it or not. And some of the long-term care insurance will also have riders on it where they're able to pay for home health services or assisted living facilities through the long-term care insurance. The third way to pay for these services is through the Medicaid program. The Medicaid program is an entitlement program, and there are income and asset eligibility requirements in order to qualify. The number one being that you can't have more than $4,000 in assets to your name in order to qualify for Medicaid. So there's particular planning that we need to do for certain folks in order to have them qualify. And it can be really devastating for families. So it's really important to get ahead of that. Going back to the 5-year look back, we really want to do as much pre-planning as we can and get ahead of an event like that. So certain folks will come in to see us because they have a serious illness. It could be a Alzheimer's diagnosis, some sort of dementia diagnosis. It could be a whole host of different health issues. If we know they're more likely to need skilled nursing care in the future, it's really important that they see us very quickly so that we're able to do some planning in advance.
Mm-hmm. How old is too old for long-term care insurance to start that process?
Well, there's no age limit on when you can apply for long-term care insurance, but it really depends upon your health. So, whether you can qualify, and if you do qualify, how affordable it's going to be. So I usually tell people, in their 40s is a good time to start looking at long-term care insurance. And then usually, by the time people are in their 70s, it may be cost prohibitive if you can get the insurance. So, oftentimes that's too late to wait. But there are some hybrid life insurance policies out there that clients, that have been helpful for clients. So You can purchase a insurance policy that has a death benefit. It's a life insurance policy. But if you need long-term care, you can use that benefit to pay for long-term care expenses. So those are becoming increasingly popular with our clients these days.
So we have had a number of questions from our listeners. So I just want to throw it out there again. If anybody has a specific question that they'd like to pose to either Kristen or Amy on this topic, we are here to answer your questions. We have a couple of minutes left, so I just want to put that out there that, contact us right in the chat box if you have something on your mind that we haven't covered. But in the meantime, let me just ask Kristen and Amy, how do you stay on top of all the latest developments with the full practice, and how do you keep yourselves sharp, if you will, and emotionally grounded to be able to deal with these incredibly emotional, scenarios day in and day out, particularly now?
Well, I mean, Kristen may say like otherwise, but I'm very lucky to have Kristen here as my sounding board. So she keeps me grounded on a daily basis. But in terms of keeping up with the changes in the law, that's something we have to really be proactive about. And we're like, we've mentioned that we're part of the NALA chapter for the elder law piece, but we're also part of some national organizations that help us keep up with changes on, say, federal estate taxes. We're very lucky to work with fabulous financial advisors, some of who are on the call today, and they provide us with a lot of research about predictions about what may be happening as a result of the election, as a result of COVID, how things could be changing in the future. And we're really lucky to be able to keep up with them as well. Looking at what the future could hold for us, it's just important, and it's important that we're able to convey this information to our clients in a way that's accessible. And we're always here to help, so we want to be sure that we're staying on top of everything.
Kristen, it sounds like you have a lot of superpowers.
I don't know about that, but I appreciate Amy's kind words. But she does help me keep me grounded as well. So it's great to have each other as a sounding board to talk to and bounce ideas off of. And as Amy mentioned, we're a part of a number of local and national organizations that help us keep up to date on changes in the law. And we also have advisors and other financial advisors and other professional colleagues that we work with that we can consult with, and they can help us keep up to date on what's happening in their respective fields as well.
Mm-hmm. Well, Melissa has a great shout out. Melissa Gray Murphy says, Kristen and Amy are such an asset to me and my clients. They are both experts in their field, and I trust them very much with my clients. Great job today. So, Melissa, thank you for saying that. Catherine's back. It's great to see multiple questions from folks. It means that we've engaged them. She says, any talk of RMD deferrals in 2021?
I'm not sure. Do you know anything about that, Amy?
No. Well, I know that we have RMD deferrals for 2020. I don't know about 2021. I think we're going to be on alert for that coming up. I think I think the reason that we're waffling a little bit is that the election, as much as we have a presumptive precedent, it really hasn't been finalized yet. We're still waiting to see that the Senate overall is going to be finalized. We're waiting for those two senators in Georgia. If it goes the way as predicted, it will not be the blue wave. It will be a balanced Congress. I think with a balanced Congress and a Democratic president, we're going to be looking at perhaps less spending, some tax increases, and maybe less legislative change. So can't really look into the future right now for 2021, but we've got a lot of advisors we work with, and maybe we can find out some more information about that and get back to you after the presentation today.
Okay, so last call for questions while I ask Amy and Kristen to give us some parting thoughts and some motivation, some inspiration.
So we're getting a lot of people asking whether it's too late now to do their planning for 2020 and get it done by the end of the year. And I'm telling clients, as we're getting to the end of the year, every day they wait, that might not be possible to get it done by the end of the year at this point, although we would certainly try. But, getting your planning in order is a great New Year's resolution to have, and something to work on at the start of 2021. So I'm encouraging people, to put that on their list of New Year's resolutions for 2021.
Before I get to your inspirational final comment, Amy, you have some more shout outs coming in, so I have to make sure that I say our good friend Al Marciano, CPA extraordinaire, I might add. He says, I second Melissa's comments about Kristen and Amy being experts in their field and trusting them explicitly. So I explicitly and implicitly trust Al. He's a good friend. And Sharon wants to know, the first place to begin is a consultation, since it seems extremely overwhelming. What time should someone plan for the consultation? So I'm thinking that she means how much, correct me if I'm wrong, Sharon, right in, but is this a 2-hour sit down? Is it a day-long thing? Or, how do you batch the assignments, if you will?
When people come to see us, we usually will just take a look at both of our workloads. If someone requests one of us, that's great. If it really can go to either one of us, we'll just assign a consultation. We tell people, again, we meet people where they're at. We can have a consultation. I had one the other day. I couldn't believe it. It's actually a very complex plan. They had all their decisions made. We were 10 minutes into it, and I said, I feel like we really need to keep talking. And they were done. They said, no, you're fine. We got it. I have other people who really do need to have that discussion with us as a sounding board over who would be managing this death plan for them, who would be their beneficiaries, and we're able to work with them too. There's no cutoff, but I would say on average, it's a half hour to an hour for our consultations.
Mm-hmm. See, that's very doable. I bet people are thinking, oh no, I'm going to be there all day, and it's going to, it's going to be a significant sentimental event. So you've treated us to some really excellent information today. Both of you, really appreciate you breaking it down for us and making it understandable, making it predictable, exuding trust and confidence in the process. You have great knowledge of what's happening as a result of your various professional affiliations, and also no doubt the tenure of the work that you have been able to do over the course of your career with your firm, which you founded. So it's a women-owned firm. So that's very interesting. Did you do that intentionally?
I'm going to let Kristen talk about this because she's actually been at this firm longer than me. So she is my senior partner here.
I'm your senior partner. So we are a women-owned firm. So we did, and that's only within the past 2 years that we've become a women-owned firm. Prior to that, we did have another partner, Irving Waldman, who is one of the founders of the firm, and he retired just last year, and so Amy and I took over at that point. But prior to that, it was the three of us. But we have every intention of staying a women-owned firm and continuing on the way we are now.
Okay, great to hear. That's very. That's a great way to go to market, I believe, because you bring your trusted self, but also bring a great deal of institutional knowledge. Lisa has one final question. She says, if we need to revise our book, would you meet with someone to give an estimate on how much this would cost? So, a way of sort of easing into the process, I think, is Lisa's question.
Yes, there's no issue with us taking a look at someone's documents, and we will let you know. What I want to tell everybody is with estate planning in particular, it's a flat fee, which means There's no hourly billing. You're not going to get a bill every time you make a phone call or send us an email. It's flat fee. There's no surprises. And I tell everybody, you can call me and email me as much as you want because I love to talk. So just bring it on. We will make sure the plan is yours, and there will be no surprises at all.
Okay, well, that sounds like a great way to end. Bring it on. And we thank you so much on behalf of all of us at the Greater Providence Chamber of Commerce for your attention and your engagement and your confidence in us. And we look forward to checking back with you in a few months to see how things are going and if any of the tax planning rules have changed as we head into 2021 after the election has been officially declared and certified, and see where we go from there. And of course, you can always feel free to get back with us should we, if we could be a resources to you or to any one of your clients. We are here as well. So thank you for being here with us today. Thank you to all of our viewers and listeners on Twitter, Facebook, and YouTube that are watching. This recording will be available for further download. And I know before I end, I just want to mention that Amy and Kristen have a slide deck that they have prepared for a follow-up. So if anybody is particularly interested in saying, well, you know, I might want to go over a couple of those points again, there is a slide deck that that can be sent to you, and you can review some of the key themes. So how do folks get that, Amy?
And I need to give full credit. Kristen prepared the slide deck. It is awesome. So it's actually really detailed about some of the different kinds of trusts that we're able to do. If anyone wants to reach out to us, you'll see the crawler there for mail at mswri.com. You could send us an email. We'd be happy to share that with you. And you can also reach out to either one of us individually. We're happy to share that.
Mm-hmm. Okay, so you can see the crawl there. Phone is 272-6300, and the law firm is Moonan, Stratton, and Waldman. So with that, have a wonderful holiday, everybody, and we'll see you next time.
Thank you,
Bye-bye.
Laurie.
Thank you so much, Laurie.